Good morning, everybody. Keith here. Gonna wait a few minutes, see if we can get some people on. Got some good information today. Been posting a lot about the UCC lately, and got some more of that information to share. Kind of wanted to verbalize it a little bit, maybe help people understand some of it a little bit better and how it works. And so basically I wanted to start out, even though we're talking about the UCC, Uniform Commercial Code, I want to start out with something known as a declaratory judgment. And I don't want people getting confused by that, but basically it's just a declaration. That's all you're going to do is just put in a declaration. In that declaration, what you want to do is you want to show the diversity of the parties at suit. In other words, you want to show that you are foreign to the fictional plaintiff that is bringing the suit. You want to show that you are a living man and that you have a person, that you're aware of that person, and the status in which you maintain in regards to that person. Whether you've authenticated the birth certificate and stepped up to be executor and have a lien on the person and doing business as and are durable power. If you don't have that stuff, that's okay. Still be honest about it, because the way these courts work is when you go in and you're not learned in this process or the procedures and facts about them procedures, you have the ability to ask for a leave of court at any moment. Every question they pose, point of clarity, point of law. But anyway, you've got that right to ask for a leave of court so that you can seek counsel in order to respond appropriately. Understand the words I'm using. These are very succinct words that you can use yourself in every situation in court. Point of clarity, point of law, request leave of court to seek counsel so that I may appropriately respond to the court. Very simple. And they have to allow you to do that. That is not up to judicial discretion. That's within the rules and guidelines of every court. You have the right to be informed. Period. And so when you make your declaratory judgment or your declaration, you're going to state that you're different. You're if the court is able to proceed with both a living man versus a person, then it will do so. But if you're clarifying in that declaration that you are not the person and it's very succinct, then that's a declaration that's on the record, and they have to be able to tell you what your rights and immunities are in that situation. And so that's what that's going to do, is they're not going to make any judgment on anything. They're just going to present information that will allow the proceedings to move forward. And that information is going to be the rights and immunities of each party at hand. And so then once you've got that declaration with all those rights and immunities, that's what you use to put the prosecution down. Okay? You're gonna use that information in regards to the person by making the declaration that they are an obligation of the United States. It is a citizen of the United States under Title 18 of the United States Code, Section 8. It clarifies that it is an obligation. The citizen of the United States is an obligation of the United States, and then under Title 18, Section 9, it shows that it's a vessel of the United States. And when we're talking about United States, under 31 of the United States Code, Section 1321, subsection 73, it shows that the United States Department of State is the fiduciary assignment of those United States citizens. it says that in 73, where it says that they are the fiduciary assignment of decedent estates and trust funds. And if you think about that, that birth certificate, that United States citizen, that person is both a part of the public charitable trust as a decedent estate. And so when we go into these courts, we make that declaration of those differences and let them know that we're aware that the fiduciary assignment belongs to the United States Department of State. And the Secretary of State at this time is Mike Pompeo. And you can address those fiduciary assignments, Form 56, directly to him. And if he tries to rebut that, you just point out, the duties of the United States Department of State, and he has to accept that. There's no way around that. Congressional record shows that he is the fiduciary assignment in those, and it shows up on the under Title 31 of U.S. Code, Section 1321, subsection 73. So learn this stuff, and now we're going to get into United States Code and understand, people. The USC is international contract law, which the U.S. federal government has to follow, and they do so by employing it within the United States Code under Section Title 28, I believe, is the contract law. We see the contract and trade laws under Title 15, but that is not enacted as positive law. That's just their contract and trade laws within the corporation. However, Title 2018 or Title 28 of the United States Code is positive law, and that's where you'll find your Uniform Commercial Code. And then your state statutes are the exact same thing. They have to abide by the Uniform Commercial Code, so they employ the Uniform Commercial Code within their statutes, and you'll have to find that per state. And the first one I want to talk about is Title 18 of the United States Code 216, where it speaks of penalties and injunctions. And it says the punishment for an offense under Section 203, 204, 205, 207, 208, or 209 of this title is the following. Whoever engages in the conduct constituting the offense shall be imprisoned for not more than 1 year or fined in the amount set forth in this title or both. And what I want people to understand is that's for each person that is trespassing, for each offense they trespass. So if you've got 30 agents all trespassing, and they've all trespassed a number of times, think about how many years that is that they have to serve. One agent making 5 trespasses, that's 5 years. Another agent making 6 trespasses. You multiply that times 30 agents, most often even more agents. So we have to understand that. And it says, whoever willfully engages in the conduct constituting the offense shall be imprisoned for not more than 5 years or fined in the amount set forth in this title or both. So understand the differences. Now we're talking, the first one said 1 year. And we have to look at the difference in the wording here. The second one says 5 years. Well, the first one says whoever engages in the conduct constituting the offense. The other one says whoever willfully engages in the conduct constituting the offense. In other words, those who already know that it's wrong to do so. In other words, officers of the law, officers of the court, all of these people that are doing this that know it's against the law because they're supposed to be learned in the law. So understand this stuff. These are penalties and injunctions that we can put against these people when we make our claim. And these are the places we find them, is under Title 18 and Title 28. Now it's got a bunch more here that I could read off to you. I'm not going to, but I will tell you. Title 18 of the United States Code, Section 216. And then it speaks of Sections 203, 204, 205, 207, 208, and 209. I suggest you look at 205, 207, and 208. Those are all very egregious offenses in my eyes, of course. But Just take a look at them and you'll see where you're going to get these suckers. Title 18 of the United States Code, Section 921, wherein we have a definition as used in this chapter. The term person and the term whoever include any individual, corporation, company, association, firm, partnership, society, or joint stock company. There's your definition of person when we go after these persons. We're going to go after them both in their personal and private capacity. So when we go in there after them in their personal capacity, we have to be sure and be aware that their personal capacity is in the corporate capacity. And therefore we have to name the right corporation of which they are working under, or corporations. Because every last one of these agencies is a subcorporation of another corporation, which is a subcorporation of another corporation, which all have the same parent corporation known as the United States. Okay, remember I was talking about Title 28. Title 28 of the U.S. Code, Section 636, speaks of the jurisdiction, powers, and temporary assignment. Learn those words: jurisdiction, powers, temporary assignment. Who has been assigned trustee? Understand, people, they're assigning you as trustee when you're actually supposed to be the beneficiary. Well, then do it in the proper manner and have no problem stepping up in the position of trustee and administrate as appropriate, being trustee of a contract that is supposed to be both beneficial and detrimental to all parties. So if the other parties have no consideration in it, then they cannot suffer detriment. Therefore, it is not a valid trust or contract. Well, where's the consideration in the birth certificate? The consideration is the securitization and put on the global market. It does have consideration. Use that as consideration for your own secured interest in that constructed instrument. Anyway, Title 28 of the United States Code, Section 636, where it talks about the jurisdiction, powers, and temporary assignment. I suggest you read it and learn it. Learn how to stick this to these people. These are the judges that we're talking about. They have certain responsibilities and duties, and their first duty in every case, I assure you, is that declaration, finding out if the parties are of like kind. In order for one party to sue another party, they have to be of like kind. If a corporation is coming at you in your private capacity, that is not like kind. If you are not able to represent the person because you don't know enough about it, then you can state that, you can clarify that, you can clarify that you know of this. But you need points of law and clarifications by people that and information that you don't have, so you need access to counsel at every step along the way. Hey, don't take that speedy trial. Take every question, every statement, every word, and clarification, point of clarification, point of law, leave of court, so I may seek counsel to appropriately respond. Period. It's that simple. Every word out of their mouth. Point of clarity, point of law, leave of court, so I may seek counsel to appropriately respond. Okay, and again, that's this Title 28, Section 636 has several pages here of things to look at, so go ahead and look that up and read it. And then another one here, we were just talking about assignment. Well, think about assignment. Assignment is the same thing as appointment. And so we under Title 11, and I know I said Title 18 and Title 28. Those are your UCC and your criminal laws that you're going to go after them in. But when we want to clear up the record, we're going to do it in Chapter 11, bankruptcy, and that's your 11 USC codes. Your Title 11 of the United States Code. It's your bankruptcy code. And under that, under section 1104, it says appointment of trustee or examiner. At any time after the commencement of the case, but before confirmation of a plan, on request of a party in interest or the United States trustee, and after notice and hearing, the court shall order the appointment of a trustee. Now the court's going to order the appointment of trustee. So at that time is when you want to step up and notice the court of the obligation under Title 18 of the United States Code, Section 8 of the United States citizen being that of the United States, and under Title 18, Section 9, wherein the vessel of the United States is that which belongs to the United States or a United States citizen. So if that birth certificate belongs to a United States citizen, it is a vessel of the United States, and it is also an obligation of the United States. And therefore, they are the ones that should be appointed trustee, not yourself, unless you know what you're doing. If you've already authenticated the birth certificate, done the UCC 1 lien, done the DBA, the durable power of attorney, and set up your own treaty and trust, then you're good to go. Probably you probably know enough to do what you do it without them. You can probably do it through the mail. Anyway, that's your appointment of trustee, and then it goes on to state why you would appoint a trustee. And the first one it puts out there is for cause, including fraud. Now, I don't know about the total accounting of these matters, Your Honor, but as a paramount party in interest in these matters, since all derivatives from any proceeds being accumulated in these matters comes from my Christian given name, then I direct this court to make an order of trustee appointment to that of Mike Pompeo, the Secretary of the U.S. Department of State, as is his fiduciary duty assigned under 31 U.S.C. 1321, Section 73. That should do it. And then, of course, it goes on, and we've got a few pages on that one as well in regards to appointing trustee. And then again, we have, again in Chapter 11 of the U.S. Code, Section 1163, is appointment of trustee. And again, it says, as soon as practicable after the order for relief, the Secretary of Transportation shall submit a list of 5 disinterested persons that are qualified and willing to serve as trustees in the case. The United States trustee shall appoint one of such persons to serve as trustee in the case. Now again, there's talking about that United States trustee, Mike Pompeo. And it says, as soon as practicable after the order for relief. So somebody's made an order for relief, and the Secretary of Transportation shall submit a list of 5 disinterested persons. And why do we have the Secretary of Transportation? Because if you look up the definition of transportation, it shows that it is a commercial act. It's a commercial act, and that's why we're doing this under Chapter 11 bankruptcy, Title 11 of the U.S. Code. We're going to close this account. We're going to bring all accounts to the proper balance, pay out all proceeds to the correct and appropriate parties of interest. Okay, and now I've got something else I want to read to you here in regards to the declaratory judgment thing. And it says, the precedent created by Filartiga versus Pina Irala of 1980 has facilitated subsequent international human rights cases, including Doe versus Karadzic and Doe versus Unokal. These cases have established the multinational corporations and other non-state actors can be held responsible for the complicity in human rights violations. So it doesn't matter if you're a citizen, a national, or an American or anything like that. The diversity there is talking about multinational corporations. So again, we see corporations. Anytime you're talking about a court of equity, it has to be a corporation, artificial person. Corporate artificial persons cannot create and attain parity with living beings. They can only create that parity with another corporate artificial person. Monell versus Department of Social Services in 1972 case. This case began as a challenge to New York City's forced maternity leave policies. Its resolution created a precedent that established local government accountability for unconstitutional acts and created the right to obtain damages from municipalities in such cases. Since 1978, this precedent has been used by lawyers and nonprofits as a tool to challenge police misconduct, civil rights violations, and other local unconstitutional acts. And I want you to remember, this was a case brought against the Department of Social Services. So it can also be used against them, all you people out there trying to get your kids back. Things like that. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. As well said by Judge Cooley, the right to one's person may be said to be a right of complete immunity, to be let alone. This is Cooley Torts 29, Union Pack Rye Company versus Botsford. Anybody has any questions about these, feel free to PM me and I can get you the information. Now this is where we're going to stick it to them, people. Everybody's been afraid of this Admiralty Maritime Court stuff. And so I'm going to spend some time on this one because this one is Title 18 of the United States Code, Section 7. Special maritime and territorial jurisdiction of the United States defined. The term special maritime and territorial jurisdiction of the United States, as used in this title, includes the high seas, any other waters within the admiralty and maritime jurisdiction of the United States, and out of the jurisdiction of any particular state, and any vessel belonging in whole or in part to the United States or any citizen thereof, or to any corporation created by or under the laws of the United States or of any state, territory, district, or possession thereof, when such vessel is within the admiralty and maritime jurisdiction of the United States and out of the jurisdiction of any particular state. Now, what did that just say? That basically said what Title 18, Section 8 and 9 both say. That the United States citizen is a vessel and an obligation of the United States under special maritime and territorial jurisdiction of the United States. That's basically all that said. Don't let all the different words confuse you. So then we look at number 2 here. It says any vessel registered, licensed, or enrolled under the laws of the United States and being on a voyage upon the waters of any of the Great Lakes or any of the waters connecting them or upon the St. Lawrence River where the same constitutes the international boundary line. Any lands reserved or acquired for the use of the United States and under the exclusive or concurrent jurisdiction thereof, or any place purchased or otherwise acquired by the United States by consent of the legislature of the state in which the same shall be, for the erection of a fort, magazine, arsenal, dockyard, or other needful building. That leaves it quite ambiguous. Any other needful building. Gee, a Department of Transportation management building. City office buildings. All of that. That's why your courthouses fly that maritime flag. So, any island, rock, or key containing deposits of guano. This is a funny one. I haven't figured this one out yet, but it's talking about guano and guano only, which may, at the discretion of the president, be considered as appertaining to the United States. Don't know what that's about, but we'll figure that out someday. I ain't worried about no bat shit for now. Anyway, there's more that you can look up. This is another one that's got some paragraphs to it, so look it up, read it, and understand it. Everything that we're talking about is, in fact, special maritime and territorial jurisdiction of the United States defined when we're talking about that U.S. citizen. Not when we're talking about us, but when we're talking about that U.S. citizen. Okay, then the next one we're going to talk about is 18 of the U.S. Code, Section 8. This is when I was telling you about obligation or other security of the United States defined. What I want you people to pay attention to here is the term obligation or other security of the United States includes all bonds. Period. Then it goes on to tell you everything else, certificates of indebtedness, national bank currency, Federal Reserve notes, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposits, bills, checks, or drafts for money drawn by or upon authorized officers of the United States, stamps and other representatives of value of whatever denomination. Understand that one. Stamps and other representatives of value. It's just a representative of value of whatever denomination. That's why we see those dollar signs with 2 hash marks and dollar signs with 1 hash mark. They're 2 different languages. One's American and one's Mexican. It's a peso. Issued under any act of Congress. And the last part says, and canceled United States stamps. Why do we have canceled United States stamps as an obligation of the United States? Because they still hold value, because they're printed on bond paper. Think about it, people. Save your canceled stamps. Title 18 of the United States Code, number 9. This, again, we spoke of earlier. Vessel of the United States defined. The term vessel of the United States, as used in this title, means a vessel belonging in whole or in part to the United States, or any citizen thereof, or any corporation created by or under the laws of the United States, or of any state, territory, district, or possession thereof. Okay. Now we know that birth certificate is a citizen of the United States. We know it's an obligation of the United States. We know it's a vessel of the United States. And then under Uniform Commercial Code, Section 9-307, it tells location of debtor. Now remember, if one corporation is making a claim against another corporation, the plaintiff is the one that's claiming that the defendant owes them, and therefore the defendant is the debtor. So when we see location of debtor under Section 8, location of United States, because we know the defendant is a citizen of the United States, therefore an obligation of the United States and a vessel of the United States, we need to know the location of the United States in order to inform the United States that somebody has brought a suit against one of their citizens. And that location of the United States is located in the District of Columbia. So remember that, people. And I'm sure most of you already know that. Now, under Title 18 of the United States Code, Section 911, I want people to understand this. The citizen of the United States can never be yourself. You are a real, live, living man. One of the people. You are not a person. The citizen is known as a person, which is a fictional or a corporate artificial person. So understand, when we speak of Title 18 of the United States Code, Section 911, it says, whoever falsely and willingly, or falsely and knowingly, presents themselves to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years, or both. So you cannot present yourself to be a citizen of the United States, and there is a penalty for that. You can only represent the citizen of the United States, period. So when you sign up for a public pretender or a lawyer, what you're doing is you're signing up for another fictional person to represent your fictional person. Whenever you reserve your rights, however, and put UCC 1-308 prior to, showing proof of intent prior to any signature, authorization, mark, autograph, or anything, you show your prior intent to retain all rights inherent and unalienable. When you sign up for a lawyer under those terms, he is no longer an attorney. He must act in a capacity of a lawyer and as a counsel. He is not to speak for you. You speak for yourself. You ask, like I said earlier, point of clarity, point of law. May I ask leave of court so I can question counsel, so I may appropriately answer the court. You never let a lawyer or attorney stand up there and speak for you. Period. They're not speaking for you, they're speaking for a person. So understand, Title 18 of the U.S. Code, Section 911, citizen of the United States, whoever falsely and willfully represents himself to be a citizen of the United States. You cannot do that. You're not a fiction. Okay, under Title 8 of the U.S. Code, I'm just going to sidetrack here because I want to show the importance of the word game that they use against us. And in Title 8 of the United States Code, Section 1401, they go on to describe nationals and citizens of the United States at birth. The following shall be nationals and citizens of the United States at birth. And the first one, it says a person born in the United States. A person cannot be born. A person can be birthed. A person can be created. But a person cannot be born. Born is something only living creatures can have. Only living creatures can be born. But again, it tells you that a national is a person. A national and citizens of the United States at birth. So I'm not a national of the United States at all. I don't claim to be a national of anything. I'm not an American national. I'm a living, breathing man. However you want to construe it, that's your definition, and it does not apply to me. Then we go on to Title 18 of the United States Code, Section 841, definitions. Remember, earlier we saw under Title 18 of the United States Code, Section 921, they define person. And here under Title 18 of the United States Code, Section 841, again they have set of definitions. And again, the first one up here is person. Means any individual, corporation, company, association, firm, partnership, society, or joint stock company. Period. And then we have Title 18 of the United States Code 18, organization defined. As used in this title, the term organization means a person other than an individual. So an organization is, if we look at, UCC 1-106, where it talks about plural. The singular applies to the plural, and the plural applies to the singular. It says, as used in this title, the term organization means a person other than an individual. So a person can be a plural of many persons incorporated as an organization. Understand that. And then I've got appointment of trustee or receiver of operation of vessels. Remember, we were talking about that birth certificate. That birth certificate Under Title 46 of the United States Code 50305, appointment of trustee or receiver in operation of vessels, appointment of secretary in a proceeding in a court of the United States in which a trustee or receiver may be appointed for a corporation operating a vessel. For a corporation operating a vessel. Okay, in this situation, the operation of the vessel is done by who? If it's done by me, then it's not I'm not a corporation, am I? So this is telling us that we have to, in the administrative, and it says up here from Title 46, shipping. Chapter 503, administrative. And that's why we have 46 Merchant Marine subtitle, USC 503 as administrative 05. Appointment of trustee or receiver and appointment or operation of vessel. The court finds the appointment will inure to the advantage of the estate and the parties in interest and tend to carry out the purposes of this subtitle. And what they're talking about there is appointing the secretary as trustee. And it says the secretary expressly consents to the appointment. So the court can appoint him, but the secretary has to expressly consent. Well, the appointment's already been made under Title 31 of the United States Code, Section 1321, subsection 73. And all you have to do is just make him stick to his assignment as already made. Okay. Title 28 of the United States Code, Section 636, Jurisdiction, Powers, and Temporary Assignment. I believe we already discussed that one. Maybe I've got a duplicate here. Let me double check that. Yes, I do. So we've already discussed that one. We're going to skip on to the next one. Sorry, folks. Let me get back to where I'm at here. Okay. Then we have, again, we're back in the bankruptcy thing here, 11 of the U.S. Code, Section 327, where we talk about employment of professional persons. So if we're going to be doing this by ourselves and assigning and appointing people, this is one of the important ones to know. It says, except as otherwise provided in this section, the trustee, with the court's approval, may employ one or more attorneys, accountants, appraisers, auctioneers, or other professional persons that do not hold or represent an interest adverse to the estate, and that are disinterested persons to represent or assist the trustee in carrying out the trustee's duties under this title. So, when we're doing this bankruptcy, understand we can employ professionals at our own discretion. And I believe, correct me anybody if you believe me wrong, but I believe in the same bankruptcy proceedings we can assign certain amounts available for transfer to these employed professionals for as compensation for their performance in the matters at hand. So understand that, people. It's just a matter of learning the words and learning how to use this shit against them. Always remember Sun Tzu in his writings, Art of War, said to defeat one's opponent without fighting is of supreme excellence. And so I prefer using words against these cocksuckers. Excuse my language. Now, under Title 11 of the U.S. Code, Section 544, trustee as lien creditor and as successor to certain creditors and purchasers. Okay, this is what I was talking about earlier when you authenticate that birth certificate, do the UCC 1 lien, the DBA, durable power of attorney, and have your trust and all that set up. You use this right here against anybody that brings any action against you. Trust as lien creditor, or trustee as lien creditor. You're the lien creditor with a superior lien on it. When you do the UCC 1, that's what you're doing is you're putting a lien against that person. And, yes, Andy. We'll put you on. I got a friend coming along lines. Everybody welcome Andy. Let me finish up here real quick, Andy. Trustee, creditor, and as successor to certain creditors and purchasers. And what that's going to do is anytime they try to bring an action to a court, again, like I said, they have to prove that they're a corporation and they're going against another corporation. And they already know this. The court knows this. And we're the ones that are trying to learn this. So understand that when they bring a claim or a complaint, what they're doing is they're suing another person. And they know this person. They already have information on this person. And they have to present it to the court. And the court has to verify the information that it is both a United States citizen and a corporate artificial person in order to give permission for the plaintiff to follow suit. That's a first. That's a must. So when people are going into these courts and questioning jurisdiction, they're questioning something that's already gone by, or they're going by something that should be questioned previous to that. It's questioning jurisdiction, question standing to sue. In other words, they have to prove that they have standing to sue, and that standing to sue means that as a corporation, they are suing another corporation due to breach of contract, or they are presenting themselves as a living being who has suffered a harm, loss, or injury and is suing another man in his private capacity as well. So if they're bringing you as a private man into court without a representative that you yourself get to pick, not them, but if they're doing that and then assigning a state appointed trustee, they're coming in as a state and then assigning one of their own trustees. That's bias. That's clear bias. So understand this stuff, people. When you become the holder in due course of the person by authenticating the birth certificate, both at state and federal levels, then you can turn around and put a superior lien on that person, the UCC 1, do the DBA and your durable power of attorney, and make sure your estate is trussed up with something of substantive value, gold, silver, property, whatever it is. You then use this UCC 11. Yes, intrinsic value.
Use the word across the water, intrinsic value. So yeah, that with substance and backing behind it. How are you, brother?
Good. Yourself, Andy? Everybody welcome my brother Andy across the waters.
It says there, across the bottom of my warning, a certificate is not evidence of identity.
Correct, they are not.
So and when they come together, when they say people, it's a body of people. It's body corporate entities, the fictions.
Yes. Anything done in commerce.
My person is always there. I always carry my person in my wallet. So should my person be called to the commercial realm, then no problem, I shall present it. However, I may require a benefit. I am a charitable man and I have a big heart. However, if I don't see any benefit for me enacting the role of the person, well, then I shall not be acting in the commercial realm. It's as simple as that. It's knowing who you are, who your commercial person is, and the two jurisdictions of the law that run side by side like oil and water. They're not to be mixed. You've got the common law at law level for the public jurisdiction, and then your person is residing in that private level, in that public level. But man can reside outside of that, operating the trust relationship which you reside within there, and you can evoke the laws of trust and equity if you cannot get the wrong righted at the common law, public at law level.
Right. And when you mentioned a couple words in there that are important to a lot of people, you don't understand it yet because there's a lot of confusion, and that is trust and common law. Your trust law, your international trust law, speaks directly of common law. That's what a trust is. It's common law. So if you look at my page now, I just recently updated my profile picture and my other picture. Look at those two pictures and understand them very well. The one speaks of that contract trust and how to develop that trust. So I suggest people, I urge people strongly to learn trust.
My commercial entity, yeah, sorry, brother. My commercial entity, when I operate in commerce with this commercial entity, I'm my equitable asset, my valuable consideration is my signature, and I can assign things to this corporate body. But
it's the transfer of your energy.
exactly. But if I was to write you a letter tomorrow, Keith, man to man, well, then I would autograph it to you. Love from Andy. There would be no corporate Mr. Title. There would be no signature. My equitable, valuable consideration would not be on the document. And it's these that we must understand what the significance is between the signature or an autograph. That they're not the same.
Right. I remember distinctly in language arts learning the two distinct differences between a business letter and a personal letter. And the problem with that I have today is that, like I said, one was described as a business letter and the other one was a personal letter. And yet no one ever informed me of what that personal meant. And so I was indoctrinated into believing that even in my private capacity, I was a person. So, and this is what we're trying to get over nowadays is the differences in discerning that we're not that person.
No. When you look in a comprehensive English dictionary, a person is a persona, and a persona is an actor. And when you step up as an actor, and in personam with an M on the end, when you're there as live flesh and blood, living man, electrolytes, heart beating, soul living, you enact the role of that person, whether it be a movie star or whether it be the person, the corporate body fiction on the birth certificate. You step up into that role and enact it. And that's why you have the acts and statutes and protocols, laws, legislation, and all these water abiding laws that are attached to it. It's all laws of the sea, laws of the water. Admiral, it's maritime, it's canon, ecclesiastical, it's from the church. And
See, that's what that's the importance of that
person lead to Rome.
Right, and that's the importance. Everybody understand the importance of the Uniform Commercial Code. It is the international contract law, and under Uniform Commercial Code 1-103, it speaks of the hierarchy of laws that my brother Andy was just talking about. It speaks of the canon laws and your common law and your ecclesiastical law and your commercial law and your all the different laws that are available to you, and it's your choice. It's your choice. You get to decide which forum that you're comfortable in regards to your knowledge. If you're better off in bankruptcy courts and doing it under Chapter 11 and just calling everybody in and saying, okay, let's clear out all the books and do a bankruptcy on everybody, then do it. If you feel better off doing it in a under your canon laws and holding the judge to his fiduciary and honorable moral duties, then he's going to vacate for lack of contract. So there's all different kinds of ways to do it. You can walk in and use right of subrogation. It just depends on your knowledge.
You would have to be careful not to suffer the court a wrong with your vexation, because you can cause a man a harm or a loss by being there in the incorrect capacity, uttering the wrong language. You have to be spot on with the verbiage. You have to know what you say. Say what you know and know what you say. It's as simple as that.
Exactly. But also, and though I I know exactly what you're talking about there, Andy, because the courts will hold you to that perfection. I also help explain to people that, one of the biggest tools in your defense is, okay, excuse me, clarity. My intent is to be honorable, and therefore any actions that have offended the court, please excuse it. Please clarify. Point of law, and allow for leave of court so I can
Absolutely.
uh,
Plain
get
language.
assistance of counsel.
Absolutely.
So don't ever let them scare you, because though you are right, Andy. They will hold you to perfection, and so that's why it's important, so important to know
Well,
this stuff
if
before
you
you
say
go in
it,
front of them.
yeah, if you say it, you've got to prove it. So it's
Right,
sometimes best saying nothing, but in their rule of law, saying nothing, acquiescence is acceptance. So you've got to know when to and when not to say anything. More importantly, don't utter
right,
anything that you can't back up evidentially.
right. And because another thing you got to remember in these courts of equity, while you're in that court, what they're actually doing is, even though there's a controversy before the court in regards to maybe a contract or presumed contract, the actions of the court itself is a development of a trust. The
Absolutely.
beginning of the court is the development of the trust. The end of the court is the finalization of the trust, wherein the charter is reached and the obligations of all parties are given.
With fair performance and exchange given, exactly that.
Yep. So even while you're participating in the courts themselves, they're constructing another trust. They're
Yes.
making another
I,
artificial person.
I don't advocate going to court. I advocate getting your paperwork in order for and on the record. First in line is first in time, according to the maxims of equity. So get your
Right,
paperwork, get your suit tailored, get it in your case, and get it filed for and on the record, and let your paperwork speak for itself. If you have to compel anybody to their fiduciary capacity or switch the trust relationship or whatever it is that you're doing, let your paperwork
yeah,
speak, because they have no obligation, they have no duty to hear the person, because we're not oathed, we are not honour bound or anything else, sworn allegiance to their society to speak their legalese language. So you're best off
right.
not being there, not saying anything as a ghost entity. You let the paperwork, let the paper. Only man can produce the paperwork, so let it speak for itself.
Right. And this is, again, I'm going to go back to the common law, because I'm a firm believer in the common law. Everything is based upon the common law. And
Common sense.
when we speak
Yes,
about the common law today, most people think that we've lost the common law, and that's wrong. The problem is that there is no longer any substantive common law. They kind of removed that from the books, but we still have the process of common law. And where do we find the process of common law? We find the process of common law in the most abundant law on the books at this time, which is the Uniform Commercial Code, which says there's a process of service. So if we served them
absolutely.
once, we served them twice, we've served them a third time, and then we've gotten tacit acquiescence every time, we now have something that is unrebutted and stands as truth in law, and therefore is a full-fledged claim that all you have to do now is place it on the record. The judgment's already been made, and now all you're doing is enforcing the collection of, and that collection of is under Title 2 of the Uniform Commercial Code, Section 607, I think. We can look that up. We can look that up, but there is an enforcement. Matter of fact, I'm getting close to that. That's one of the things I wanted to point out in this stuff. The next thing I was going to talk about was the jurisdictional immunities of foreign states. And that's why it's important when you get involved in any of these things, you make your declaration of being foreign to the corporation that is called itself a fictional plaintiff. And you discern exactly what that foreign status is, that you are a living being and they cannot create parity with you. That if they want to conduct business with your person, then they must do so through this party, that party, or whoever you've assigned as trustee.
Agent,
Then,
agent of the agency.
let's see here. 3-306 of the UCC speaks of claims to an instrument, and that's your security interest in it. Your interest in it because it was named after you. It was derived after your first given Christian name.
Yeah, you're given Christian calling. Yeah, that's your
Right.
vested interest. They've taken your
And
family name. They've uppercased it, text Latin dogma, what we would call here bastardized the language, and they've uppercased it to sign language, which there is no law of the land dictates that man should read sign language. So
right.
it's all hand behind the cloth. It's, you know, smile behind the veil. We're taught at school, indoctrinated in our cognitive dissonance to think that uppercase capitals are good, put them at the beginning, good. But we didn't realise until later on in our life that we're making jurisdiction of the law by doing that.
Right. And see, another thing I want everybody to understand here, it says in the Uniform Commercial Code under section 3-302, it's very specific in the language, and it says holder in due course. And what we're talking about here, and the first word says holder.
The title holder, it's all deeds and titles. Who holds it?
Right, means to physically hold. And what we're talking about here is that birth certificate. You can order a copy of your birth certificate and have it in hand when you walk into court. You are the holder in due course of that instrument.
Person for and on the record at court. You present the person there. It clearly states on the document that it isn't you. So there it is from the record, the person. What do you require of either man? If I am to give performance here today, then I require just and fair compensation for my given performances, surely.
Right. And the one thing I want to make sure that everybody understands here, we talk about that authenticating the birth certificate. You can do so in 2 different languages. You can do so by sending them to the Secretary of State and federal level and having authenticated. Or you can walk into court with it physically in your possession because nobody else has the right to possess it, nor the ability to prove that right. Therefore, you just holding it as holder in due course is authenticated in physical form.
Possession is 9/10 of the law, and you are the sole shareholder bond.
Yep. That's why we have these squatters' rights being contested and stuff, because corporations cannot own real property. Only real people can own real property. So when you have these abandoned properties and you walk in there and you have some corporation trying to push you off. Say what again?
Only man can have possession. Corporation can have nothing. Corporation is stationary. The same as the person.
And that's what they can never prove.
Person. It's stationary until you move it. Until you move it, it's stationary. Any corporate body, any fictitious entity, it's laws of the water. And we've just got to know who we are, know thyself. It's all written in the Bible, who you are, who a person is. God isn't a respecter of persons.
Correct. Okay, then right back to the birth certificate, the 2 different languages that I was just talking about. Under UCC 3-308, it says proof of signatures and status as holder in due course. And that right there, we're talking about the authentication of that instrument by writing. But like I said, that's a reduction of the word. In beginning was the word. So if you can walk into court with that document in hand and tell that court that I am the holder in due course, no one else has the right to step forward and hold this document in their hand because it's my calling on it. There's nothing more supreme than that. Sun Tzu in The Art of War said, to defeat one's opponent without fighting is of supreme excellence.
I, man, have not consented or authorized any man here to put their fingers into my bond. Whom has the authority and the jurisdiction to do that? Bring forth the man making the claim today.
Yes, yes. The next one I want to talk about is the next next code is section 3-07, where it speaks of notice of breach of fiduciary duty. Learn this one, people. Fiduciary means an agent, trustee, partner, corporate officer, or director, or other representative owing a fiduciary duty with respect to an instrument. What this says, it has absolutely nothing to do with the parties, but the instrument itself. He has a duty to the instrument. Exactly. He doesn't have a duty to me. He has a duty to the U.S. citizen that is presented as the defendant. And you have to hold him to his fiduciary duty.
Responsibilities, liability. When
Exactly.
you take on the role of a person, it's like putting on a coat. It comes with fine, forfeiture, responsibility, liability, and duties, and it can be incarcerated, sprayed, maced, and shot. And before you've got time to take this coat back off again, all these things could happen to you. So when you comprehend whom these are, the fiduciary capacity is written in the trust law. And to know who you are as set law, man is set law. The person is the beneficiary. Yep. And man is born unto the land for remedy. Born unto the land for remedy.
Yes.
Remedy, the benefit of his person. So once you know how to enroll that, I, set law, this beneficiary, that only leaves one position open in the trust triangle, and that is the trustee. So any given corporative entity coming forth for you, you appoint them immediately in the trust relationship. Here you are, here set law, here's the beneficiary person, and you appoint them at the top as trustee to oversee, discharge, or dispel any claim made against the family estate. And they say the family estate because it's the family name that they have capitalized and taken from you.
Exactly, exactly. So 3-307 of the UCC, that's your fiduciary stuff. That's what you hold them to. Now here's the one I was speaking to earlier in regards to the hierarchy of the laws, and that's UCC 1-103. It says construction of uniform commercial code to promote its purposes and policies, applicability of supplemental principles of law. And that's what we're talking about, the principles of law. Remember I said...
the principle. What is the principle? You write a notice to the you say notice to principal is notice to agent. Notice to agent is notice to principal. Principle is at the top. It's the principle of law. It's the principle of man. This is the common law as well. It's what's right and proper to us. If it's not right and proper, if it's not just, you can't justify it. There's no justification. If it's not right, then it must be wrong. So it can't be proper. It must be improper. And if you've got any one of these three elements missing, then you're not going to have a leg to stand on in law.
Exactly, exactly. I spoke the fourth of a judge in a post I put up yesterday. If you haven't seen that, Andy, check it out. His weakest leg is the leg of his private standing. No matter what a judge does, he's the one that issues verbally words. He's the one that authors what is written on those orders. And therefore, if he's the one that's going to author that, he's the one being held in his private capacity.
Yeah.
So
our words, if you write the word words and then you bring the S from the back and put it to the front, it spells sword. Our words are our swords. The pen is mightier than the sword. And then our words are spellings. And when we cast our spell, whether it be verbally or whether you clarify it on paper, you better be, because you are casting a spell every time every time you make a sound. Simple as that. Sometimes you can stand silent and still cast a spell because the vibration resonance that we resonate at still sends the mood in the room. We know we can feel that from up to 12 meters away. All these things, it's all they're bearing.
Yep. And then the next one here, UCC 1-105. This is your severability. It says right there, severability. This speaks of your foreign capacities. Remember, I talked about anytime you get in started in anything, make your declaration that you're foreign to this corporation. Show the foreign differences. This is what we're using here, 1-105, severability. If any provision or clause of the Uniform Commercial Code or its application to any person or circumstance, circumstance is an event, is held invalid, the invalidity does not affect other provisions or applications of the Uniform Commercial Code, which can be given effect without the invalid provision or application, and to this end, the provisions of the Uniform Commercial Code are severable. And what that's talking about there is that the event of the person being birthed is invalid. How do we know this? Because the formation of the trust doesn't follow international trust laws. Who is the trustor?
This is not man. This is a registration of an event. It's as simple as that. This
exactly.
is chattel.
Therefore,
it's cargo birthed into a warehouse, into a ward, into a wardship. You are made a ward of the state. The state take a husbandry role over every man and his dog on the land until you reset the trust capacity within this status.
Right. And that's basically what it is. It's a trust fraud. It's a trust and securities fraud. And
it isn't a fraud.
This is your out.
Fraud. I would say, Keith, it isn't a fraud because the maxim of what you don't have to know you're in a trust to be in a trust. So they haven't exactly frauded us, but there is ill will, if you will, or there's malfeasance of office there. If you know, it is malicious because they haven't indoctrinated us correctly. They certainly haven't educated us. So had we have known in the first instance that this is all trust capacity and it's trust language that you have to evoke to make man be live in the eyes of the law instead of a dead entity lost at sea, we could enact all this a lot earlier, and none of us would be caught in the perpetual debt system that man is slaved into. Today we don't bear chains, we bear debt. You know, we're all enslaved through that birth certificate, through the perpetual debt system.
But see, any valid trust, all parties know each other. And that's why quasi-trusts are considered unlawful. A quasi contract is just basically the formation of an unlawful trust. You've got 3, 4, 5, you might even have 8, 10, 12 different parties. But nobody, they're branches of government that don't know what the other branches are doing. See what I'm saying? So you've got this monster out there with all these different arms reaching into this pot, and nobody knows whose arms they are, but they all know they want a piece of it.
They're all operating as a private corporation, as a private fictitious entity. They're all registered separately instead of being as one. The whole thing is
right.
The maxim of law. When foundation is wrong, all is wrong, and that's what what the level of the wrongness is. It starts at the bottom.
Yeah, and see that birth certificate trust is basically just a 3-party contract. That's what a trust is. It's just a 3-party contract. Whereas your quasi contract, it employs 3 parties, but they aren't all contracting with each other under the guise of full disclosure. How can it be when they don't know what each other's doing? You have cases where, say, a child custody case. Now you've got the Department of Social Services involved. You've got the local county or city municipal police involved. You've got the county police involved. You've got the state police involved. You've got the county attorney involved. You've got the several magistrates involved along different levels because they've got child orders or guardian ad litem orders. You've got guardian ad litem involved. You've got other charges involved that are brought out of criminal fraud in and of itself. And the shit just goes so deep, and I can't fathom why people aren't so tired of it already. That they're not at the point I am. Yeah. So, but yeah.
In the language, what is a child? what is it? A child is property of course. I keep bleeping with the
Yep.
messengers. Yeah, a child is property of corporation. We've got to know these words. What's a parent? You know, the parent. The parent the asset, the property from the state, because they have the vested interest through the Social Security. So I'm not a parent. I'm a dad. You know, I
Right.
don't have a child. I have property. I have an asset to me. What's proper to me? My property. My property is proper to me, exclusive only to me within the society, for me, from the fruit of my loins and my vested interests.
Yeah. And, basically, what it comes down to is no matter who created it, it's a person created by the United States, and therefore they're the ones that supposedly have control of it. But no matter who created it, it was created in your as a derivative of your calling, and therefore you have what's known as a security interest in it. Now, having that security interest and possession of it, as well as being the original genuine creditor, you now have three legs of a four-legged table, with the United States only owning one leg, as being the one that created that fictional person. So,
man is
my point.
The person is the debtor and standing.
Right.
Only a person is in debt. That man always credits the account through your signature, your valuable considerable. It's your valuable
right
consideration that man creates it with. We always create with our own bare hands. Persons are in debt. Man can't be in debt. That's why Jesus hung on the cross to forgive man of his debt.
Yep. That's our true redemption. We don't need redemption manuals. We don't need to, and that's what I hopefully one of these days I'll get to it where I can just walk into any court and not have to worry about any documentation. I can just speak my word and they'll, oh, okay, yeah.
Me too, brother.
You know, that's a big head yet, but
from the heart.
Yeah, exactly. Speak the truth. I've been talking to people many years now. Why would you an attorney? An attorney could never tell the truth for you better than you could. Never. And so when it comes down to it, we got to go into these courts with knowledge. And that's knowledge of who we are.
My battery's going to go soon, brother, so I'm going to have to shoot off. But and if I can just narrow it down, keeps going mad as well. If I can narrow it down, it's to legally own nothing and to benefit from everything. That's all I'll say.
Yep. And that's exactly what it comes down to. And the person, United States person, when we get a hold of that motherfucker, we grab it by the neck and we squeeze the life out of him and collapse that motherfucker. We need to develop our own person, create our own person. That way, when it comes to the legs of the table, we have all four legs. All right. Well, hey, I appreciate you joining me today, brother. It's been great. I heard you say your battery's running low. Go ahead and get that thing charged, and we'll talk again soon. All right.
We'll catch up soon, brother. Thank you for having me on and sharing our little wisdom together.
All right.
Love, brother.
Yeah, brother.
Love, everybody. Thank you for watching.
Yeah.
Thank you.
All right. For everybody else, I'm going to continue on with Title 18 of the United States Code, Section 5, where it defines United States. The term United States, as used in this title in a territorial sense, includes all places and waters, continental or insular, subject to the jurisdiction of the United States, except the continental zone. Now, all places and waters, that's where it says that they went on to the land. They are now on the land. These gold fringe flags in the courts. That's that special Admiralty maritime jurisdiction. So, understand that United States defined extends its reach all throughout this country. Title 18 of the United States Code, Section 6, Department and agency defined. As used in this title, the term department means one of the executive departments enumerated in Section 1 of Title 5, unless the context shows that such term was intended to describe the executive legislative, or judicial branches of the government. Notice that word, of the government. Remember, Title 28 of the United States Code, Section 3001 subsection 15A, talks about the United States is a federal corporation and not a government, including the judicial procedural section. So this here is telling us that department and agency defined is not government, but a corporation. Okay. Title 18 of the United States Code, Section 18, organization defined. I read this one to you earlier. As used in this title, the term organization means a person other than an individual. So an organization is multiple. It is a plural term, meaning more than one person. So, when we talk about the Uniform Commercial Code, when we start signing these documents known as contracts or offers to contract, we need to start understanding how to answer these, respond to them appropriately, conditionally accepting them. We need to learn how to condition ourselves. Somebody asked earlier, FARA, Foreign Agent Registration Act. When we go into these courts, we want to make sure that the prosecution, along with having proof, sufficient proof, on and for the record before the court, showing that the citizen of the United States named as the defendant has been particularly and concretely identified with certainty, and that he is an artificial person, so that the court then can give permission for the plaintiff, the fictional plaintiff, to follow suit against a fictional defendant. The court has to give permission for that parity to be created and attained. They cannot do so with a fictional corporation filing suit against a living man. So when you have documentation that has 2 or 3 different spellings of the defendant, make them clarify which one is the defendant. Upon that clarification, you will come to find out that the defendant is a citizen of the United States, and that it is a corporate artificial person, and that you are being listed as trustee. You are not the trustee. You are the settler, as Andy said. You are the settler. The trustee is the man on the bench. Clarify that. Excuse me. Clarification, point of law. Leave of court to ask assistance of counsel so I may better respond. The court. Understand this stuff, people. Anytime you're in these courts and you have people in the spectator's galley, you can ask for leave of court, turn around to that spectator's galley and ask somebody in the galley a question. They have not crossed that bar. They are assistants of counsel. Period. Who else is to rebut that? Prove that they're not. Prove that if they can't answer a question for you freely and willingly and correctly, or even incorrectly, that it is not assistance of counsel so long as they gave you better information or a direction to ask others. Period. Quit letting these people fucking push you around. Start standing up for yourself. Start educating yourself. Quit letting them indoctrinate you with their public education. You go to school from kindergarten or even preschool all the way up to 12th grade to get a diploma and a pat on the back that says, yeah, now you're a good little slave. And they convince you somehow to go get a higher education and go to college. So you go to college and you get this other degree and you get a pat on the back again and it says, yeah, now you're a professional slave. Okay, now somehow they convince you to go back to college, get a higher education so you can get this master's degree or something, so you can turn around and get in front of everybody else and indoctrinate them into the same thing. All you professors of law out there think you know so damn much. Then how come you aren't teaching it? They're not. They're teaching legalities. If they were really teaching the law, they wouldn't be doing it just in the fucking educational forums. I know religious programs that teach me to adhere to step programs that teach me to be honest. Who am I supposed to be honest with? People behind closed doors or everybody? Think about it. Well, oh, there we go. We're back. Anyway, just so you know, you gotta stand up before the court, as well as their foreign agent registration documentation. Always request that. Always require that. Demand it. Who are you to stand up here in this court of equity and portray that you have some damn license to practice law when there is no such as truly required? The foreign agent registration documentation. Require this stuff. Require the funny guy in the clown suit up there in the bench. Require him to provide his anti-bribery statement. Require this stuff. Require the W-9s. Pull forward all W-9s. Are we not in a court of equity? Are we not constructing some kind of trust agreement here, so that when it's all said and done, all parties assigned to certain performances, and they are compelled by these proceedings to perform as such? Is not the defendant going to be required to pay fines, fees, or taxes, no matter how it turns out? Because if he claims proceeds from these proceedings, then he has to pay the taxes on them, on any income derived from his name. Understand the words they're using against you. These courts are running, what they're doing is they're taking those bonds and they're pooling them together and securitizing them so they can sell them on the global market. That sale on the global market acts kind of like a CD account. It has to be out there for a length of time, and it has to mature. So at the end of the year, depending on how many people had faith in it and bought into it, will determine how much income it provides. So learn this stuff and learn how to administrate your own affairs, and do so by learning the international trust laws, developing your own trust so that you can operate within that realm. This Uniform Commercial Code is a step off of that, and it gives you under 1-308 your reservation or retention of rights, as I call them, the applicability of a hierarchy of law in notice and knowledge of letting other parties know that you're foreign to them as a non-obligated secured party with interest in the matters, because everything's deriving from your name or from your calling. Learn this stuff and learn how to put it together. And one of these days we'll have it all, and we'll be able to put it on to our children, show them how to operate in commerce appropriately, go forth and prosper and be abundant. But yeah, the FARA, Foreign Agent Registration Act, make sure that these prosecutors are being held to present their documentation, make sure that the funny guy in the clown suit is being held to show his oath and his bond and anti-bribery statements. If they're not doing this stuff, then do your notices, do your common law process. You've been noticed. You have 21 days to respond. You've been given a second notice after failing to respond to your first notice. You're now given 10 days to respond. Now you have 31 days. You've got the 21 days you've given them. You've got the 10 days you've given them. That's 31 days. Now the third response, 72 hours. That's another 3 days. You've given them a total of 34 days, plus any days interim that it took to draw up new documentation to present them to them again. So now you have 3 times they've tacitly acquiesced, which is unrebutted affidavits. That's what you follow. You do your presentment of notice of dishonor, that they've trespassed, whatever, and